Well, welcome back to the Men's Divorce and Cordell Virtual Town Hall. I'm Scott Trout, CEO, Managing Partner of Cordell Cordell. And thanks for joining, because we know you have questions, and that's what this time is reserved for. It's to try to give you some direction, not necessarily clear answers, because as I've always said in each of the town halls and podcasts, whatever we do, this session, this format can't replace a consult with an attorney who practices exclusively in family law like we do here at Cordell Cordell. So you can't take this as legal advice because we don't have enough information, but we want to give you some general direction, some good education, and that's why we're joined with a panel of Cordell Cordell attorneys, and today is no different. We're joined by Christina Wilford in Jacksonville, Florida. Welcome.
Hey, good afternoon, Scott. Good afternoon, everyone.
Thanks for joining. And we're also, to round out our panel, is Asa Neff up in Albany, New York. Welcome, Asa.
Hi, good afternoon, Scott. Thanks for having me on today.
Great. Well, today we want to just get some questions answered. So the way to do that, for those of you who have joined, is to submit a question in the Q&A section. Go ahead and just give us your first name, your city, your state. That way we can get an idea where you are. And you can do that now. We'll get to your questions here shortly. And we want to go ahead and give you some direction. But also a heads up, take a look and watch out on social media. For June, we'll be celebrating Father's Day all month, and we're going to be doing some special things. So keep an eye out for that. We'll be doing a focus on dads throughout the country and trying to give them some resources, things that are not just education on the law and what's going through divorce or modification, but really about things during and after, about what we can do to get you some appropriate resources. So we'll celebrate dads the entire month of June. So take keep an eye out for that as well on our social media, as well as our website. And as I mentioned, a consult, if you want to schedule a consult, you can do that online at cordellcordell.com, or you can give us a call at 866-DADS-LAW. By going to the website, you don't even have to pick up the phone or speak with anyone. There's a live calendar. Find an office near you. So let's do this. We'll get to our topic. I want to talk a little bit about child support with, it's the season, graduating high schoolers. We want to talk a little bit about what happens then for a very brief moment. But let's go ahead and get to a break. We'll be right back after this. All right, welcome back. So let's make sure, submit your questions now. We'll get to those here in just a minute or so. We want to get through those. We have some already that we'll go through and try to give you some direction. So get some paper out and a pen, take some notes. And again, find us online at cordellcordell.com. Asa, I know Asa and Christina and I were talking off camera. We were talking generally about the high school season, the graduation season, and what happens with child support. Every state is different. We use the words emancipation, in terms of basically when are they old enough to not be subject to the judgment of divorce, whatever it may be, the rules of the court, child support payments, visitation, parenting plans, all of that. And every state is different. And so, Asa, I want to go to you. And one of the things, I had a client email me this week with questions about what to do. His daughter is leaving come August to go to college. He's obligated, in his judgment, to pay child support through age 21 here in Missouri. And then also he's paying half the tuition, room, and board for her to go to college away. So she won't be living with either parent during the school year. And that's required. There's some case law that states that parents in Missouri have to pay for the college education. So that raises some questions about, okay, why would I pay room and board, basically another home, a third home for my child to live in, and still pay my ex child support? So it raised a lot of questions. And so, Asa, what happens in New York? What kind of are you seeing? What does the law talk about? And what are you seeing from judges in terms of the ability to try to alter that plan if they're facing that?
Yeah, those are all good questions and concerns we hear from a lot of dads who get into the situation where they're paying basic child support to their ex and their child goes off to college. So in New York, like Missouri, child support continues until 21. Now, there are circumstances when a child can become earlier emancipated as early as 18 if they, for example, are not going to college or not living with the parents, if they're financially independent, and there's a variety of other circumstances. But if a child is going to college, then child support continues. Now, we run into a couple of different situations. Sometimes a agreement that might have been reached at the time of a divorce will specify the specific situation. I know when I'm drafting an agreement, we anticipate college. We also anticipate that if a parent is still paying child support when a child is going away to college, that they could seek a reduction based on contributions, usually just to room and board. Now, if you don't have an agreement, if child support was ordered by a court, there is case law to support being able to seek a reduction of your child support obligation based on those contributions. So it's never guaranteed. Nothing's ever guaranteed, but it's certainly worth having a discussion with an attorney in your state to find out if those options are available to you. Because in New York, there is an ability to seek a reduction in child support based on contributions that you're making to room and board while your child is away at college.
Yeah. I mean, it is the same here. And so the situation I'm recommending is a number of ways where I've seen judges do a couple things. They may reduce the child support, still give some money to the spouse to maintain the residential home in the event the child returns. They may redirect the money to the child in college, which oftentimes is not necessarily a good idea. They may not be mature enough to understand how to spend it appropriately. So it may not be spent on items that you really intend, or they may terminate it, abate it during the months in which a child is out. So there are a lot of options. And I think that's why it's kind of like 'tis the season to begin thinking about that. If you're in a state in which your continuing obligation rolls past 18, and then you may want to have a consultation just to see what is next for you and what really is appropriate, and take a look at your judgment. Then have someone who practices exclusively in family law, like we do, give that answer. So Christina, I know we were talking off camera. Your state's a little bit different in Florida, and many of those living there don't have to worry about that necessarily, right?
It's certainly different, Scott. So we in Florida have no obligation to support a child going to college, and our support terminates earlier. So what everyone's looking at in Florida, under normal circumstances where we don't have a child with disabilities, that would obviously be an exceptional circumstance, would be that the child support will continue beyond the age of, normally it terminates at 18, but it can terminate beyond the age of 18 if the child is still going to school and is a senior in high school. However, under no circumstances will it automatically go beyond the age of 19. That would be an automatic termination. We also have no law whatsoever that requires the parent to support a child's college expenses. And we see a lot of agreements that come up where parents have thought, well, that's reasonable. I'm mom, I'm dad, I'm going to support my kid through college. And I'm all for that. Absolutely. If you have the financial means, support your child going to college. Being a parent doesn't terminate at 18. It's forever. But in Florida, you should never legally obligate yourself to it, because once you have, there's no recourse for the court to terminate it for you, because maybe your financial circumstances have changed. And so do so voluntarily out of the goodness of your heart, but not by court order, because the law is that the judge can't order you to pay for that.
Yeah. I mean, it is something it's a good use of time. Have a conversation. And even if you're in Florida, you may be in a state you don't know what the age of emancipation is, or your decree is confusing. I know that's a shock. It is oftentimes, very wordy, many, many pages long. And why we lawyers draft things like that, I'll never understand. You use big words, and instead of very simplifying the notion and what can you expect. But a consultation is a way to do it, especially in a time like this when you're approaching high school graduation. And you may be even paying into college. And you may be watching and saying, okay, my state is 21, but my child's failing in college. They've dropped out of college. What happens? Those are great things to be thinking about now that we're at the end of the school season, as we're approaching. Do I pay for summer college? So many questions. And I thought it was appropriate to talk about at today's Q&A section. So we do have some questions. So let's go ahead and get to those. And remember, you can submit them right now. You can go into the Q&A section and just give us your first name and where you're living and your question, and we'll try to get those answered. So Joe from Michigan, I'm going to give this to Christina. Married for 15 years, no children. I was told moving out before filing is a bad idea. Most of the household items are mine, bought before our marriage. Can I move, take my belongings without prejudice of the court? And this is in Michigan. And let me just throw something out, and I'm interested in your thoughts, Christina, because, it's one of the 10 stupidest mistakes. We've done that seminar so many years that's in there, and that is moving out. Now, we don't say automatically move out, automatically stay. It's one of those where we often say actions have consequences in divorce, and it's a very emotional thing. Now, Joe seems to be thinking through, and it's the right thing to be doing, and that is a very cautious approach to making a decision to do it. I've often said in these seminars that if you wind up leaving and a lot of the items are yours, it is not unusual for them to disappear and for those items to be sold, to be given away, to be left out in the snow, set on fire. And I use those examples because those are all examples in the 30 plus years I've been doing this that I've seen happen when someone moves out. But Christina, I'm interested in Florida. Here in Missouri, there's nothing to prohibit someone from moving out. I don't think the judge is ever going to look or frown upon someone moving out, especially if you have domestic violence issues, you don't get along. But there are a lot of strategic reasons to stay. And I always say, why leave, make someone very comfortable? Now you have duplicate household expenses. You got to go get another rent, another mortgage, more furniture. I'm not sure I would do it. If I want to force someone into the negotiating table, I want them to be uncomfortable. And, I'm going to order food that just doesn't necessarily has a, odor throughout the house. I'm going to leave the windows open, whatever it may be, to think, okay, I've got to get you out of my life. If that's what you want, create that scenario. And you've stayed in the home. But Christina, what are your thoughts?
So everything is obviously individualized to each client, but I always start with a cost-benefit analysis of all the facts. And number one is there a threat of domestic violence going on? Because if it is, then honestly, in Florida, you don't lose any property rights whatsoever if you leave. And so you have the ability to leave and still go before the judge and say, this is either my premarital property, this is my marital property. I want my interest, and the judge is going to give it to you regardless of whether you're still there or not. However, it is easier and interesting. It's an interesting way to leverage it if you're still in the home, because it does tend to expedite the proceedings, because somebody wants to either stay in the home, they want to sell the home, they're a little uncomfortable, and that can definitely help with negotiations. I completely agree. And the other thing is, I have also seen a lot of things go missing, get burned, disappear, get sold, and it is very hard to recover things. And at that point, you're looking at a he said, she said. And under those circumstances, you don't know what the judge is necessarily going to do if a TV goes missing, if a speaker system goes missing. So those little things are really, it depends on how important they are to you.
Mm-hmm. It is. It is proceed with caution. And if you're determined to move out, and I have no problem with my clients moving out and taking things with them, just doing an inventory so that you know what you're taking. And you could even send an email. Those are things I suggest to my clients, is sending an email of what you've taken so that your spouse has that. And it's very clear. If they don't respond in any way, then the counter argument is there's no objection. They understood what we took. But it is a really important strategic decision, and it is judge by judge. I think you want to have a consultation with one of the Michigan attorneys we have to say, okay, how's a judge going to react in Ann Arbor or Detroit or Troy or wherever it may be, or Grand Rapids? And they'll be able to tell you, yeah, this judge is not going to have a problem doing it. So I think that's kind of the answer, really, the short answer. But we often take, this is one of the first mistakes guys make, is doing this decision without taking the steps to get really good, solid information. So kudos to you, Joe, for doing it. And along those lines, another question submitted. Asa Marcus said, during our mediation, I allowed my ex-wife to stay in our home under two stipulations. The home had to be financed, removing my name, by March 10th, 2023. In the event the home couldn't be refinanced, the home was to be put on the market, ready to be sold on or before May 1st, 2023. My ex has failed to refinance the home. She says she's now in the process, but I'm the only person on the mortgage. I haven't been given anything to confirm this, nor have I been asked for a payoff. May is coming up, obviously, and the home is not ready to sell. I reached out to see if she had talked to a realtor. I heard no response, and then I got an email from her lawyer asking why I'm texting her since she's in the process of a refi. From what I understand, the court order document is what we should be following, and come next week, the house needs to be on the market. I've already prepared a motion, ready to file it. Is there anything else I can do or I should consider? Obviously, we're not going to be able to give you legal advice on this, Marcus, but what do you think, Asa?
So it sounds like Marcus is doing everything right. He's been reaching out to his ex-wife. You're, documenting it all, I would hope. And documentation is very important in these types of situations. So if you're texting her, make sure to keep those text messages. If you have any communication with her attorney, make sure to keep those communications in writing so you have a record of it. A lot of times in our agreements that we reach, there's a requirement that you provide notice of default, and it has to be a very official notice of default. It's worth talking to an attorney. I don't know if you still have an attorney, but you certainly could speak to an attorney to find out if that's a provision of your matrimonial agreement and if that's something that you should be doing as well. This is very state specific, and whether or not she's in willful violation of an agreement will depend on if this is just something that's going on with the bank and it's not through any fault of her own. So a motion might be a little premature if she's doing everything that she can be doing. So again, I think it's very important that you talk to an attorney about making sure you're doing everything you really need to do, and then following all those steps and finding out if it's going to be worth it to file the motion now. But so far it sounds like you are doing everything right.
Yeah. And I think there's some caution there in terms of following the actual deadlines, because I know what judges will do if she is truly in the process of refining and just hasn't been able to cross that finish line by the date in there. Judges are going to give them a little leeway so long as they've been making adequate progress and really making good faith efforts to get that done. And as Asa said, maybe it's a bank issue, whatever it may be. So no, that doesn't mean that you shouldn't continue to pursue your rights, consult with a lawyer, respond to the lawyer saying, provide proof that you're refinancing, and I'll just sit back and wait. But anyway, something to think about. Let's see. Christina, Jacob says, Jacob in Texas, after my divorce, I unilaterally changed my health insurance plan to make my finances work. I'm covering the health insurance for myself and my kids. I changed to a high deductible plan. The divorce stipulates that the insurance should be provided for the kids, but doesn't specify a plan. The divorce also stipulates that all costs not covered are split 50-50. My ex is claiming I'm not allowed to change the plan unilaterally per joint legal custody. As such, she is trying to negotiate an alternative to paying 50%. She's upset that I changed the plan without consulting, and she's now on the hook to pay for more. She sent me a letter and is threatening mediation if I do not negotiate. What do you think?
So I think in most jurisdictions, it would boil down to the exact language of either the final judgment that divorced you or the agreement that you signed that was then ratified by the court, because the language is going to control. And that's what the judge is going to be looking at, because let's say she goes to the court and she says you did something wrong. Then the first thing the judge is going to do is look at the language of the agreement or the court order and say, what does it say? So if it says something along the lines of the father or the husband must maintain health insurance, and it doesn't say the policy that was in place, the same policy or a similar policy that was in place at the time of the divorce, or it doesn't say that mom has input on which policy can be selected, and it only states that you have to maintain insurance coverage for your child, then I would say that under those broad circumstances that you would be perfectly fine. Mm-hmm. If it says anything to the contrary or there's little stipulations in there, then you have to be very cautious, and it's going to boil down to the exact reading of the order. So I would have a local Texas lawyer take a look at the document and give you some guidance, because certainly if there is some wiggle room and you have some exposure for litigation, then maybe it is something that you want to try to resolve by agreement. But otherwise, if the lawyer is confident that the plain reading of the order gave you the authority to do whatever needed to be done, provided that you're providing that coverage, then you should be fine.
Yeah.
And it's just a bluff.
I think so. I mean, no decree is going to expect that you have to maintain this for years and years. Jobs may change, policies may change, the company may change, the benefit structure itself. And in this situation, it doesn't appear that both or either are getting an unfair advantage. They're both on the hook for 50-50. Now, his premiums are down and lower, but I think that's certainly, as you suggested, what is important is to ensure that the decree, the judgment is clear and provides the ability to do something like that, or doesn't say the converse, that you cannot change. You must maintain something of similar cost, expense, and overages. So having one of the Texas lawyers take a look at it is definitely the right advice. All right, Asa, we have about 5-6 minutes left. Tony says, my soon-to-be ex-wife and I are separated, going through a divorce. Some circumstances have come up in which I need to help my parents with monthly payments. Currently, I'm also voluntarily paying the rent and some extra support to my wife since she does not have an income. I'm not mandated by the court to do so, but regardless of how the marriage went, I want to make sure she is taken care of until the divorce is finalized. My lawyer tells me if I don't continue giving her money, she will likely go to court and file for temporary alimony, and at that point, the payments will become mandated, so she'll have no reason to settle. And the amount the court gives may be more. By paying both my parents and my wife, I'm left with nothing at the end of the month. My question becomes, do I stop paying, even though it's not court mandated, or do I keep sending her a check to avoid this? And I know this is a conversation I have a lot with clients who are the breadwinner and what they should be doing. What do you think, Asa?
I think, like Christina mentioned before, it's a cost benefit analysis. If you cut her off entirely, there's always a risk that she's going to go to court, and you could end up with a higher payment. And you also have the attorney fees associated with having to go back to court. Continuing to pay her sounds like an extreme financial strain. So maybe there's a middle ground somewhere. Maybe there's a way for you to afford supporting your parents, paying something to your wife, and still having something left over for yourself, because you shouldn't be working and having nothing to show for it at the end of the day. Mm-hmm. It's a tough financial analysis to do. So, you should be continuing to speak to your attorney, looking at your finances, looking at what you can afford and what you're willing to do. But it's always a risk to cut somebody off financially completely when there might be an obligation down the road, and leaving it to a court can be a big risk, because you don't know necessarily what a judge is going to do. There's a best case scenario, there's a worst case scenario, and there's often some wiggle room. Mm-hmm. But if you can find a scenario that's going to work for you and maybe work for your soon-to-be ex-wife while you're going through the process, then it could be worth trying to find some middle ground there. But again, it's a conversation you really need to have with your attorney. Look at your finances and see what you're able to do.
Mm-hmm. Yeah, it is definitely a tough situation. And I think it is one of those where you look through your attorney and you sit down, go through the finances from the perspective, because it's maybe a judge situation where the judge is going to say, okay, something's paid, but not the max. And you just don't want to upset the judge. They're derailed by emotion. So again, it's having an analysis done with your attorney, sit down and make an informed decision on what to do. Christina, Will in Jersey is in the middle of a custody battle with ex-girlfriend. She has our son during the week and is living with family members that I do not trust. I see my son every weekend. In the past week, there's been zero communication coming from her, no matter how much I've reached out. She normally texts like clockwork and tells me what time I need to pick up and drop off. She's had past drug-related issues, and I believe she may be checked into rehab. Our hearing is in 30 days. Since we have joint custody, shouldn't he be living with me while she's in rehab? Can this hurt her case in court for not notifying me and having her family members hide it from me as well?
That's certainly an important question to ask. And I understand that when you're sitting in a situation like this, where you believe that your child is with inappropriate caregivers, where mom might be in rehab, that 30 days sounds like an eternity. Mm-hmm. And so I think at that point, especially if you're represented by counsel, you need to talk about whether an emergency motion is warranted. Are you not hearing from your kid? Do you not know about your child's well-being? All of those are very important questions to ask, because there may be a recourse to get your facts in front of a judge sooner. Because 100%, if we're in a situation where you're the parent undeniably, then and one parent is unable to care for the child, then in most jurisdictions, the court is going to agree that the child should be with dad or mom when the other parent is available to take care of that child. But certainly this is a situation where I would want to know more facts about whether this is potentially an exigent or emergent circumstance that could get you in front of a judge with either a ruling with or without her participation if she's off the grid.
Mhm.
There are things that can be done in those situations. And if not, then maybe the attorney can explain to you why it doesn't rise to that level. And you can use all of that to your benefit at that upcoming hearing, because certainly in any custody case in any state, parents are required to co-parent with one another, and they're required to keep each other reasonably informed. That's just parenting. And so if she's not communicating with you, if she went to rehab and is hiding something like that from you, then that's certainly something that you and your counsel need to talk about as you prepare for that upcoming hearing, regardless of whether it rises to the level of an emergency or you're just going to your hearing in 30 days.
Yeah. And it may be, and it depends on your jurisdiction, the local rules, the scheduling order. If I wouldn't wait 30 days to try to see what happens in court and whether or not that evidence comes out. You may want to ask your lawyer if you can schedule a deposition of her family members and just directly ask them and say, has she been in rehab? Where has she been? Get some information. And you might be able to, through use of discovery, find out more information that you can now prepare in advance. You don't want to wait to try to ask questions you really don't know the answer to in a courtroom. Try to get as much as you can. You're likely going to get some objections from, privacy laws, but I think it's relevant. And if she's relapsed into drugs, I think that's information, at least in my jurisdiction, I think it's relevant as it relates to custody issues and the ability to care. Certainly, absent some other order, I think that the natural parents have the rights to the child. So I think I would get with your lawyer, not wait 30 days, see what discovery rights you can have, see what you can do, and find out more information and try to press them as much as you can. Maybe that triggers a settlement negotiation, especially if she's in rehab now. So, all right. Well, that's all the time we have. Thanks for joining, as always, and submitting your questions. Look out for next month as well, as we do the same thing. You can log on, get your questions answered right here. Otherwise, you can check out our resources on our YouTube channel. You can also go to CordellCordell.com, not only to get more information, find an office near you and schedule a consult. We likely have an office right near you where you are. So check us out or give us a call at 866-DADS-LAW. Thanks for joining. Until next time, have a great week.